Mr. Chisholm.
May it please the court. Lance Chisholm from Shelby County. I represent the petitioner, Carlos Gonzalez. At this time, I would ask for 2 minutes of rebuttal. The first issue I would like to discuss today is whether counsel was ineffective for advising his client not to testify in this case. Just jumping right into it, counsel gave 3 or 4 reasons why he did not advise his client not to testify. The first reason was that, he could not corroborate the self-defense claim. In other words, he could find no other witnesses to corroborate, the petitioner fired in self-defense. Well, again, our position, as I argued in the brief, is that you don't have to have corroboration for self-defense. It would have been enough just for the client to get up there and give his, his testimony. So that's not an objectively reasonable basis. The second issue is counsel felt that jail calls really hurt the client. He said, they put a gun in his hand. Well, many of the witnesses...
It's more than that. It is, he gave conflicting statements in the jail calls.
Well, I was going to get to that part too, but the first thing he kept saying was, put a gun in his hand, and I just want to quickly address that because, a lot of the witnesses on the state side also, said Mr. Gonzalez had a gun out there, so that was in the discovery. He knew that was coming in. And also his own client told him, at one point, yeah, I shot the gun. So he shouldn't have been so upset about those jail calls putting the gun in his hand. Now, it is true he was a little concerned about the inconsistency because at first Mr. Gonzalez told his mom, no, I didn't shoot anybody, and this is in the jail call. And then he said, yeah, I did shoot the gun, but it was in self-defense. So even the jail call there, even though it is inconsistent, Mr. Gonzalez, I asked him at the post-conviction hearing, well, why did you tell your mom 2 different things? And he's like, well, I knew they were recording it, first of all, and then second of all, I didn't want to make my mom worry, so that's why he said at first he didn't do it. And I think that, that could have been explained pretty easily to the jury. He had 2 good reasons, and overall, I think the jail calls would have helped him because he did admit it was self-defense.
So, Mr. Chisholm, though, I want to make sure I understand the facts a little bit too, though. No one actually saw, if I understood, they saw your client with a gun, but no one actually saw your client shoot. Is that correct?
My memory of this transcript is that there was testimony that he was seen shooting, if I remember correctly.
Okay.
And if I'm wrong about that, I'm wrong, but it seems like they looked up.
The reason I ask it that way is because I do recall from the briefs that there was a lot to be made of. It was dark, it was a chaotic scene, this, that, and the other. And so for an attorney to say, gosh, I can't find anybody to support this alibi claim he has, or that it was self-defense, not alibi, self-defense. And if I put a gun in his hand, that doesn't look very good. And so if I put him on the stand, he's putting a gun in his own hand. So my best shot is to rely on the chaotic nature, the darkness, this, that, and the other, and the fact that no one, at least this is kind of how I read it, and I may be wrong, that no one really actually, they saw him with a gun, but no one actually saw him shoot anybody. You don't think that's a reasonable defense strategy? Because the only people backing up his self-defense is the guy on trial. If I can keep my client off the stand and do everything I can to keep a gun out of his hand, so to speak, in front of the jury, you don't think that's reasonable? Just because it doesn't work doesn't make it not reasonable.
That's correct. It is, we give a lot of deference to trial strategy, but my argument in this particular case is that, all the discovery seems to be pointing at your client as being the shooter. Your client's even telling you, I shot, in self-defense.
Yeah, but the jury doesn't know what your client's telling you.
I know, but I'm just saying that I think at that point, and we've got some law to kind of guide this, the Bates factors. It talks about, when you should advise your client to testify or not. 3 of these factors actually weigh in our favor. One is, could the defendant give the jury his full version of what occurred? Well, he could have in this case. He could have told, why he shot. He's the only one who knows why he shot. Secondly, could he be impeached with prior convictions? The state never even filed a 609 notice in this case. So, I think the only thing he arguably had was a attempted altering a license plate tag conviction, like a B or A misdemeanor, maybe even a C. So I'm not even sure they could have used that one, but they never filed a 609 notice. So that factor weighs for us. And then the last one is, could the petitioner explain the relationship with the victim? Well, he could have said, yeah, this victim is in a gang too, a rival gang. And that would have really painted the picture of what was going on that night. Because the way the facts look here, it just looked like the Playboy Serenos came up and just started yelling out, Playboy Serenos, and started attacking just a group of innocent people in the parking lot. And that's just not what was occurring. So, in this court, in the Olive case, also said you can look at inconsistent statements when you're trying to decide if you want to advise your client to testify. But again, I think in this case, when you weigh that little inconsistency that could have easily been explained versus, advising your client not to put on this self-defense, I think, the inconsistent statement shouldn't have weighed that heavily in trial counsel's mind, is my argument. That was objectively unreasonable to put that much weight into that little jail call inconsistency. So that's the position on testifying. We are saying it was deficient performance. The next prong is prejudice. And I would respectfully submit, if Mr. Gonzalez had testified at this trial, it would have made a difference. He either would have been acquitted on a self-defense, instruction would have been given, and the jury would have found the state did not prove beyond a reasonable doubt that it was not self-defense, or he would have gotten a lesser included offense, like a reckless homicide or a negligent homicide or voluntary manslaughter. Trial courts seem to say that he was not very credible, but it didn't seem like she didn't go into a whole lot of detail as to why. I think she pointed out some things, like he didn't say who he was shooting at, but I think when he said he saw bullets, saw a muzzle flash and heard bullets coming by his ear, I mean, that's enough that you're in fear. You don't have to really say exactly who you were shooting at. So I do think his story is logical. I didn't see anything about it that on its face did not look credible. I think the post-conviction court, mentioned there were no other casings found on the scene. That is true, that's my memory, but the other people could have used a revolver, or maybe they picked up their shell casings. There's some explanations for that. But overall, I think Mr. Gonzalez's testimony. Oh, the other thing the post-conviction court said, well, even by your own client's testimony, they were the aggressors. They attacked the Polonis, but really all he said was the guys in his car said, oh, there's Cholito in them, and they ran over there. He never testified, oh, they went and attacked them with bats or whatever. That was coming from the Poloni side. They were the ones saying that the Serenos attacked him with bats. And then also, even if we conclude that the guys in my client's car got out and did attack the Poloni's people, my client did not attack them. He was in his car, made a U-turn, got out. Bullets start coming at him, he starts shooting. So he himself was not a first aggressor in this situation. I think that's important too.
To assume all that, Mr. Chisholm, we have to go back to a statement you made as you kind of started going through that. The post-conviction court didn't find your client credible.
That's true.
Well, so you just gave us a list of, and I agree, great arguments you could make, but the post-conviction court said your client who's making those arguments is not credible.
I think
we have to consider them as not credible.
I think this court should find that the evidence preponderates against that factual finding she made. Would be my position.
How do I do that if the basis of the factual finding is that the witness who made the statement's not credible? I can't review the credibility. You're right, I can review factual determinations, but if she's saying the person who made these factual statements is not a credible person, then there's not a reason for us to look at.
Again, I go back to, she really didn't get into much detail as to why he was not credible. I mean, she pointed out his story she was pointing out flaws in his story, but this court can look at his story, I think, objectively, and if the story looks logical and doesn't look far-fetched or whatnot, I think this court can say there's nothing that's not
But
credible.
that's a credibility finding. We can't make that.
Well, I still stand by, I didn't see a basis to find that his story was not credible. I mean, just because
Are you
someone's...
saying that the trial court has to explain why she finds a witness not credible? She can't say, after listening to witness X, I find witness X not credible. She has to explain why?
I mean, I think it would be helpful to put something in the record so we can review why she's, I mean, I think she at one point did mention his demeanor, but, I mean, just saying demeanor without more, so, yeah, I do think there should be more thorough findings on that. So that's issue one. Now, issue two, even if this court rejects issue one and feels like, hey, there was a good strategy here, this advice not to testify was sound, my second issue is that counsel should have adequately explained the pros of testifying, the advantages of testifying. Because in this case, trial counsel admitted, I asked him, well, did you tell him, hey, you need to testify to get a self-defense instruction? And he's like, I don't recall if I did that. Well, did you tell him he needs to testify to have any hope of getting a lesser included? I don't recall that. Did you tell him he needed to testify to be able to tell the jury the other guy, the victim's in the Polonius gang? I don't remember. And then lastly, did you tell him he needs to testify so he could explain why he made those two statements in the jail calls? He said, no, I did not tell him that. So the point I think that it's important here is that as attorneys, I think we have a duty, even if we have in our mind a certain strategy we want to go with, to at least educate the client on, hey, these would be good reasons you do need to testify in this case. Hey, everybody's saying you're the shooter, and, if you want to have a hope of, like, getting something lesser than, second-degree murder, you might want to get up there and you're not, you'll get a self-defense instruction if you get up there, and they have to prove that beyond a reasonable doubt. You might get a lesser. It gives the jury something to think about. Like, these should all be explained to the client, and once he hears all that, if he decides he still doesn't want to testify, then that's fine. You did your job. You put it all out there. It does not appear that that's what happened in this case. Mr. Gonzalez said trial counsel didn't explain any advantages at all. And trial counsel really didn't rebut that. He's like, I don't recall, and I think this would have been noted in his file if he mentioned these things. So that's a separate issue than issue one. This is a different issue. One thing that's kind of is another credibility issue, trial counsel said he told the client, look, if you testify, you got a good record. You can't be impeached. Petitioner said he told me your record's going to be used against you if you testify. And so, the court credited trial counsel's testimony, but again, I submit that trial counsel's memory of this case seemed a little blurry numerous times. The court will see when it reads the transcript. This is petitioner's only case. I mean, he remembered, he was very accurate in a lot of the details, so I would ask the court to credit his testimony, and that's a big misstatement if he did, in fact, tell him they're going to use your record against you when they didn't even file a 609 notice. That's a huge error. So now there is that little part about the Moman hearing where the client got on the stand and said, yeah, he explained the pros and cons to me. Post-conviction court put a lot of weight in that, but, what he said was, look, the lawyer told me, kind of like, you need to get up here and say this and this, to get through this. So he had a reason. But even if this court feels like he lied there, and, about the pros and cons, just because you say a lawyer explained the pros and cons to you, that doesn't mean they explain all these pros, Maybe he just told him the one pro that he said he did tell him, which is, hey, if you testify, the jury can hear your side of the story. Maybe that was the only pro he told the client. And in a case like this, that's not enough. You need to tell him these other pros, too. The last issue has to do with this picture. It's a picture of the victim with a bunch of other people I'm alleging are gang members, and it says Polonius at the top. Now, appellate counsel raised this on appeal, saying the court should have let it in But the problem is, he did not make sure the amended motion for new trial was in the record. Therefore, this court never got to this issue about this photograph. Now, the post-conviction court concluded it was deficient performance not to put make sure that picture is in the record. The trial court ended up concluding, one, that picture was not authenticated because no one could say who took the photograph. And also, it was not relevant because no one could say anyone in that picture was in the Poloni's gang. So that's what the trial court ruled. Now, on appeal, appellate counsel Mr. Scholl argued, look, that's very relevant. It shows, it paints the full picture of, this is a gang war, basically. It also shows the client's state of mind, what he would have been thinking, knowing these other guys are gang members. So he argued those 2 points on appeal.
So, Mr. Shiz, let me ask you this, to the merits of that claim. If an individual posts something on their social media account that includes other people and a caption they put on a picture, how does that come in? It's not the defendant's social media account. The defendant, there's no proof the defendant took the picture. There's no proof that the defendant put the caption up there. We don't know who did it. How does that come in?
I think Mr. Trial counsel said, Judge, his exact words are, this came off Facebook. And you're right, he didn't say like whose page or anything. That's why I argued he should have called Ms. Hernandez to at least say she got it off the victim's page. But true enough, we don't know where it came from at the time this was in front of the trial court. But what I argue on authentication is that 2 things. One, under 901B1, if someone says this is what it is, basically, and under 901B4, appearance, contents, internal patterns, distinctive characteristics, you can look at all this stuff. Here you had a photograph of like 15 to 20 young men. One of them had a machete. A couple of them were throwing gang signs. All of the witnesses said that the victim was in there in the picture. One of the witnesses said the victim was throwing a gang sign himself. You have something spray painted at the top there, or airbrushed in, saying Poloni's. I mean, just like taking in the totality of the circumstances, that's for a jury to say. I think that's been authenticated. This is a picture of a group of guys who are in a gang right here. I mean, this is...
Well, but how does that prove they're in a gang?
Well, again, throwing the gang signs.
So if I take a picture of you and write Vice Lords across the top of it and post it on social media, does that mean you're a Vice Lord?
I think it's been authenticated enough. It should go to the jury at that point, as if the people are posing with gang signs and so 20 people and, the picture. It's a jury question. The law says we don't have to introduce the photographer who took it.
But who would identify it? Who would authenticate it?
Who's authenticating it?
Well, the Mr. Jesus Vila and Jose Vila said, yeah, that's my brother in the picture. He's throwing a gang sign, one of them said. So they put him in the picture. I see my time's about to run out, but I just feel like that photo would have really made a real difference in this case, Your Honors. And
Thank you, Mr. Chisholm. You still have your 2 minutes for rebuttal.
Thank you.
Mr. Barker?
Morning, Your Honors. May it please the Court. Benjamin Barker on behalf of the state. Your Honors, this Court should affirm the post-conviction court's denial of relief because the post-conviction court properly concluded that petitioner did not receive the ineffective assistance of counsel. I'll start where Mr. Chisholm started. Trial counsel's advising petitioner not to testify was just a reasonable decision. It was consistent with trial counsel's overall identity theory, which he had done investigation, even tried to see if he could find anything to support a self-defense theory, and just couldn't. So he decided that identity would be a stronger theory of the defense. It was consistent with that theory, and especially so given that petitioner made these not only inconsistent but also really damaging statements in the jail calls. And trial counsel testified at the post-conviction hearing that he did not want petitioner's testimony to corroborate the state's evidence that he was the shooter. Now, yes, Mr. Chisholm is correct, that there's no independent corroboration necessary to establish self-defense, but it seems obvious that what was going through trial counsel's mind at this time was that if he only put petitioner up there to make the self-defense claim, the jury just wouldn't believe it. That was all reasonable performance, and there's just no deficiency here. And there's no prejudice either. Petitioner testified at the post-conviction hearing. He gave the testimony that he would have given at trial. The post-conviction court did not view it as credible. Even so, though, that doesn't undo any of the state's trial proof that petitioner fired his gun without provocation and that the only spent casings found at the scene came from petitioner's gun. Respectfully, the arguments on this point are really just nothing more than kind of Monday morning quarterbacking at this point, which is not how we measure trial counsel's performance at the post-conviction stage. To go where Mr. Chisholm went next, petitioner was not prejudiced by appellate counsel's failure to ensure that the amended motion for new trial was in the record. I have to concede that was deficient performance for him not to ensure that motion was in the record, and that resulted in waiver of his issues. But there's no prejudice because, as laid out in the state's brief, this photograph issue just did not have any merit. Trial counsel tried to get it in at trial to establish that the victim was involved in this gang. But the photograph was irrelevant, really just nothing more than a character attack on the victim. Hold this photograph up and say, see, he's in a gang, he's bad. But beyond that, it wasn't authenticated at trial. And trial counsel just couldn't find any witnesses to overcome that hurdle. And the witnesses that petitioner presented at the post-conviction hearing don't overcome the authenticity problems either. Ms. Hernandez testified that she downloaded this photograph from Facebook, and she could identify the victim in the photograph, but she couldn't identify any of the other men in the photograph, didn't know where or when the picture was taken, who took it, who uploaded it to Facebook, whether it was altered, who might have put that Polones word on top of it. Her testimony just would not have authenticated that photograph. So it was not deficient for, on trial counsel's part, there was no deficiency. And just to kind of add to this growing pile of evidentiary problems with this photograph, that word Polones is also hearsay. It was an out-of-court statement being offered in court to prove the truth of the matter asserted therein, here to show that these men in this photograph were members of this gang. So yes, it was deficient performance on appellate counsel's part not to ensure that the amended motion for new trial was in the record on direct appeal, resulting in waiver of these evidentiary issues. But because this photograph issue was meritless anyway, there's no prejudice. I have covered what Mr. Chisholm covered. I'm happy to talk about any of the other issues if this court has any questions. Otherwise, the state asks that you affirm. Thank you, Your Honors.
Thank you, Mr. Barker. Mr. Chisholm, you have 2 minutes. You don't have to use it unless you want to.
Use it, Your Honor.
Okay.
Thank you. I just want to briefly respond to the hearsay argument. Now, that very well may be an assertion. Polonies, that could be a hearsay. I recognize that. But I think even if they would have, marked that out, it would have been helpful just to show the picture and have the testimony of the victim was there with gang signs with these group of people with the machete and the guns. So we don't even need the word up there. We still could have, that photograph could have been helpful nevertheless. I also want to say the post-conviction court put a lot of stock on this photograph issue by saying, well, it wouldn't matter. The whole defense in this case was one us anyway, But, I think I asked Mr. Johnson at the post-conviction hearing, would this have changed your advice to counsel or to petitioner if the photo would have come in? Might you have asked him, advised him to testify? And he said it could have, So I think that's one thing to keep in mind, that had that come in, it could have changed things, reasonable probability on the testifying issue.
What was Ms. Hernandez's relationship to the victim?
She was Mr. Gonzalez's cousin, my client's cousin. I don't think she was related to the victim.
Okay. And she couldn't say he was in a gang?
She could not say the victim. Let me think how she recognized the victim in the picture. I think she may have said thought he was in a gang. I'd have to, haven't read her testimony in a while, but yeah, I think she may have thought he was, but she recognized him in the picture, and he was throwing a gang sign, if I remember correctly. That was the victim. And then lastly, even if your theory is identification, you still want this picture to come in to give the jury something else to think about here when they're assessing Mr. Gonzalez's actions. Now, the very last thing is the picture was not made a part of the record either, and I say both counsels should have made sure the picture was in the record, because this court could have said, well, not only is the amended motion for new trial not in here, but the picture's not in here, so they should have ensured the picture was in there too. And so I'd ask the court respectfully to reverse the post-conviction court and remand for a new trial.
All right, thank you, Mr. Chisholm. Are you appointed on this case?
I am. Your Honor.
Once again, we do appreciate you. Your brief was excellent. Appreciate you, your continued service to the court.
Absolutely, my pleasure.
And thank you to the state as well. The matter will be taken under advisement.
Thank you, Your Honor.
Call the next case.
Brian Howard versus State of Tennessee.